Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about parole ineligibility in second-degree murder. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Salehi was convicted of the second-degree murder and sentenced to life without parole for a period of over 10 years. The mandatory minimum sentence for second-degree murder is life without parole for a minimum of 10 years, but judges retain the discretion to increase the length of the parole ineligibility period. Unfortunately, there's not a lot of law on when judges can increase the parole ineligibility period, particularly when dealing with the personal circumstances of the accused. In this case, Mr. Salehi was suffering from Parkinson's, which obviously had an impact on his ability to be in custody and had an impact on his anticipated life expectancy, so allowing him a shorter period of parole ineligibility closer to or at the 10-year period might be something that would be more appropriate in his circumstances. Mr. Salehi asked the Supreme Court of Canada to answer what is a very important question. How do we frame the calculation of an appropriate parole ineligibility period for somebody convicted of a murder offense in circumstances where they have devastating health issues that may impact their stay in prison when compared to the rest of the population? The role that a person's health and the future of their health condition, where it is a condition that deteriorates over time, is something that should be taken into account in determining periods of parole ineligibility. So shouldn't the Supreme Court of Canada give some guidance to sentencing judges? Because certainly this individual is not the only person who's going to have a health condition that is facing a lengthy period of parole ineligibility above the minimum period set by the criminal code. And it would have been nice for the Supreme Court of Canada to set out a clearly articulated test of how this is to be determined, rather than leaving it simply to the discretion of judges without any significant guidance from a higher court. Hopefully, the Supreme Court of Canada has another opportunity in the future to consider these periods of parole ineligibility as they relate to health conditions and provide some guidance to sentencing judges so people know what to expect upon receiving a conviction or upon pleading guilty and going into a sentencing hearing. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.